I'm Bonnie Roden, a family law attorney at Roden Law Group in Brevard County, Florida. Today I want to introduce an important topic in Florida divorce law, equitable distribution. This is the legal process used to divide assets and debts between spouses when the marriage ends. If you're going through a divorce or just want to understand how property division works in Florida, this video is for you. So what is equitable distribution? What does it actually mean? A lot of people assume that divorce always results in a 50-50 split of everything, but in Florida that's not necessarily the case. Equitable doesn't always mean equal. It means fair based on the circumstances of the marriage. So the courts look at a variety of factors when deciding how to divide marital property. They consider things like the length of the marriage, each spouse's financial situation, and whether one spouse contributed significantly as a homemaker or a caregiver or as a provider. So what gets divided in equitable distribution? Well, it only applies to marital assets and debts. That is property that is acquired during the marriage, regardless of whose name is on it. It also divides your marital debt. So if what you have acquired is debt or accumulated, then that will be divided as well. So some of the things that would be divided could be a bank account, it could be real estate, it could be retirement accounts, could be a trust, could be businesses, and it could be debts like mortgages, car loans, credit cards, even personal loans. Usually it's helpful to have promissory notes, and repayment schedules can also be divided. And it doesn't matter if your spouse knows about the debt or the asset. It simply matters that you have accumulated it during the marriage. So not everything gets divided. Non-marital property, like assets you owned before the marriage, or inheritances that came in before or during the marriage, or gifts that were specifically given to one spouse only, are usually excluded from the process. However, there are cases where non-marital assets can become marital property, and that's where things get a little sticky. So we have commingling. What is commingling? So commingling is what happens when non-marital assets get mixed with marital assets, making them subject to equitable distribution. So if you have marital money and you put non-marital money into it, it's impossible to tell them apart. So here are two examples of where this happens. You inherit money, you deposit it into a joint bank account used for marital expenses, or deposit it into an individual bank account where you also put marital money, such as your paycheck. It doesn't matter if it's a joint account or an individual account. It matters what's inside the account and what type of funds that inherited money is going to be mingled with or dumped into a pot with. Another example is if you own a house before you're married, if you add your spouse onto the deed, that will likely become a marital asset unless you have some sort of a property agreement saying that it's only for the intent to maximize homestead tax exemption or some other type of valid reason why the name was put onto the deed without intending a gift. Also, if you own a house before marriage and you pay for the house, the mortgage ongoing, or put in a pool or some other type of improvement, you will be commingling in a way as well. So you will be granting your spouse some sort of marital interest in the property. We'll cover that in another video. It requires its own topic. Let's talk about debt a little bit. So debt is divided as part of equitable distribution. And here in Florida, the court treats marital debts and marital assets the same way. That means if you or your spouse have accumulated debt during the marriage, could be credit cards, car loans, mortgages, personal loans, those debts are shared as part of equitable distribution. Now, keep in mind, this is not limited to just debt that is known. So if you happen to be married to a spender, and they are out spending all kinds of money on things and racking up credit card, even if you don't know about it, it could be considered partially yours. Student loans are another big one that people don't realize. I hear often that, well, so-and-so, I supported him or her through their schooling, and they have all this debt, and now I have to pay part of that school loan, but they get to keep the degree. So the answer to that is, well, yes. If you don't want to be liable for student loan debt, then you need to have some sort of a prenup or a postnup, or some type of other contract that will limit your exposure to that. So if one of the parties wrecked up debt in a way that is considered reckless, an affair, gambling, a highly risky attempt at an investment that didn't have a reasonable expectation to return what the investment was for, it's possible those situations may be treated differently by the courts. But unfortunately, getting in front of a judge to have that argument is likely going to cost you $10,000 or $15,000 or $20,000 to get there. So it's much better to have a contract in place ahead of time and have open books between you and your spouse, because during a divorce, all of that's going to be looked at. All right, so how do courts decide what's fair? So Florida law has several factors that the judges will consider when dividing debts and assets. So I'll give you an example of 5 of them. So one of them is going to be the length of the marriage. Another is each spouse's financial situation and earning capacity at the time of the divorce. So if one is highly educated and will be advancing in their career, and the other one has been a homemaker and doesn't have a degree and has no ability to catch up their finances, then that would be part of the consideration. Third one would be contributions to the marriage. So who is the provider, who is the homemaker, what's it worth? And then we also have whether one spouse wasted or misused marital funds. And a 5th one is going to be health of the parties. If one party has developed a debilitating disease during the marriage, then it is very, very possible that the court will say that person deserves a greater amount or unequal distribution, with more assets and less debt being assigned to them. All right, so to keep these short, I'm trying to keep them at about 10 minutes. What do you do if you're facing a divorce? Best thing you can do is be informed. Gather your financial records, bank statements, property deeds, loan documents, anything else related to your assets. The more prepared you are, the smoother your process will be. Here at Roden Law, we serve clients all throughout Brevard County, from Titusville to Melbourne, the beaches, and all the way down to Grant, Valkyria, and in the south end of the county. We always have consultations that are a courtesy. If you have some questions, any of our attorneys will be happy to get on the phone with you and answer questions and provide you with information. In the future, I'll be covering more about the specific aspects of equitable distribution. So this is just the intro, so stay tuned. And if you found this helpful, be sure to like, comment, and subscribe to stay updated as I get the following segments taped and edited to post. Thanks for watching, and I'll see you next time.